Welcome to Womble Bond Dickinson's series of intellectual property top tips. Here we aim to provide you with useful guidance on how to protect your investment and innovative efforts through intellectual property rights. Intellectual property, or IP rights, can help you protect your brands, inventions, products, designs, and even creative works. In this installment, we will take a look at how you can protect your brand in the United Kingdom and the United States through the registration of a trademark.
It is useful to start by considering what is a brand. Historically, ranchers would brand their livestock to demonstrate which animals belong to them. Today, a brand does a similar thing. It signifies to consumers that your goods and services originate from you, rather than other people or companies. The concept of a brand is generally broader than simply a trademark. A company's brand might also include what consumers think about a company or its goods and services when they see the trademark. It could evoke ideas like high quality or technically advanced, but could be as simple as fun or good value. Registering your brand as a trademark allows you to prevent other people or businesses from using that mark without your permission in order to benefit from the reputation and brand that you have built up around your goods and services. There is no such thing as a worldwide or global trademark. Trademark rights are territorial, meaning that the rights will extend to a particular country or geographical area. The laws that apply to registering a trademark will therefore be the laws of the country or area where you apply for protection.
With that in mind, let's start with the law in the UK. In order to be capable of registration as a trademark, the sign must be capable of distinguishing the goods and services of one business from those offered by other businesses. So what sort of sign could this be? Traditional trademarks include words like company and product names, personal names, numbers, and logos. The name and various logos of Womble Bond Dickinson used in relation to our delivery of legal services are examples of these. Trademarks can also take the form of sounds like jingles, colour and colour combinations, and designs and shapes of products. Other kinds of possible trademarks include position marks, multimedia or film marks, and even hologram marks. So it is quite a broad spectrum of the types of signs which could be registered as trademarks. However, certain signs are not capable of registration in the UK. Some of these exceptions include where the sign is not sufficiently clear and precise, so it is difficult for other people to tell what your trademark rights protect. Where the sign is not distinctive or is otherwise customary in the current trading practices. Remember, the trademark must be able to set apart your goods and services from those offered by other companies. Where the sign would be descriptive of the kind, quality, quantity, purpose, value, origin, or other characteristics of the goods or services. Where the sign is against public policy or morality or is intended to deceive the public.
Now that we've covered the UK, let's review the law in the United States. In the US, there is a federal statute that sets out the requirements for what can be considered a trademark. Under this statute, a trademark is any designation or symbol that identifies and distinguishes the source of goods and services from others. To determine trademark rights, the focus is on the mind of the consumer and whether that consumer associates the mark with a particular person or company. That association can be created in many different ways. Trademarks are traditionally thought of as words, or a combination of words, images, designs, shapes, symbols, and colors. However, they can also be three-dimensional designations, like unique product packaging or storefront designs, motion marks such as holograms and poses, and can also include non-visual trademarks like sounds, scents, tastes, and textures. Any of these are possible, as long as the consumer recognition with a product or service can be reasonably shown. The federal statute also identifies what cannot be registered as a trademark, including some that are expressly barred, such as marks that are deceptive to consumers, immoral, scandalous, or that would serve to disparage a person or group. Marks that contain the name, portrait, or signature of a particular person. or otherwise falsely suggest a connection to a person, unless that person has given written consent. Marks that compromise a flag, coat of arms, or other symbol used by government entities either here in the United States or any foreign nation. Another common obstacle to registration is marks that merely describe a function, feature, or other aspect of the goods or services with which it is intended to be used. The exceptions that we have discussed in this installment, both in the UK and US, do not cover where the potential trademark conflicts with any other trademark that already appears on the register. However, earlier rights owned by another business or person can also be a common obstacle to trademark registration.
Now that you know what brands can and cannot be protected by registered trademarks, the question is, why seek registered protection?
The benefits of seeking registered protection include: subject to certain conditions, including proving use and paying renewal fees, registered trademark protection can last forever, giving the trademark owner the longest kind of intellectual property protection.
Your rights are clearly defined by reference to a public register and give you rights extending beyond your own goods and services, which can include preventing other people and companies from using a sign identical or similar to yours.
Trademarks are also recognized rights in other contexts, for example, objecting to identical or similar company names, or seeking transfer or cancellation of identical or similar domain names, so you can use your registration to better protect your brand. This can be much easier and less time and resource consuming than having to establish unregistered trademark or equivalent rights.
If you want to know more about protecting your brand, please contact the intellectual property team at Womble Bond Dickinson. We hope you have enjoyed this intellectual property top tips video. Thank you for joining us.